Hello, everybody. Hi. Shelly babes, you're too funny. I love you. Hi. Oh, yes, I'm on. I'm on. Yes, I did. I went live. I hit the button. Oh my gosh. She's been literally bugging me when I finished my shower, and she was like at the door like, "Harumph. Like, ready. Let's go. Let's go." She was pushing me to get done and out, and it's not me you want. You want Ava. And Ava knows it. Actually, Ava knows. Ava wants treats. That's what Ava wants. Hi, Ava. Hi, prettiest girl. Yeah, hi there. Here she is. Made of all fluff and stuff. Made of all fluff and stuff and sweetness and joy. Yes, you want this, don't you? This. You've been patiently not so patiently, but you've been waiting. Not so patiently. What if I just give it to you like this? The chat would riot. Hi, Billy. I know, Billy, this is not for you. And you are mad about that. Billy mad. I know. All right, let's have some prairie recipe with chicken and beef in hearty gravy. Yes. Yeah. Oh my gosh. Yes. Okay, I'm going to put this on the floor. I just took a shower. Yes, there. My gosh. And she'll be back in a minute, folks. Truly a minute. Me too. I gotta wash my hands. Okay. Let me finish this. Oh my gosh. Back to our regularly scheduled hellos. Hello, crazy old lady. It's the echo is all in your head. Hello, Emily. And hello, Shelly babes. Hi, Nana Laura. Oh. Well, I did meal prep up a dozen eggs with some cheddar cheese in the muffin tins. So it could be. It could be. I have decided, and I'm pretty sure I'm accurate on this, right? The gauge of how healthy a food is for you is how farty it makes you. The more you toot, the better the food is for you, right? Right? Legumes, beans, they're super healthy and super tooty. And that's why they have that nice little nursery rhyme for them. Eggs, broccoli, everything that's good for you. Yeah, that's what it does. I love you, and thank you for the super chat and the suggestion, though I'm not sure we're going to go beyond that part of the conversation, but we'll see. We'll see where chat goes. Oh, I love that. Hopefully the chat and I don't cause gas, though, after I just get done saying anything good for you. Hi, glad to see you. Hi, Robert from Cologne in Germany. Good morning. The best part of waking up is not hearing April sing that song. Hi, CE. Good to see you, love. Hi, Art over Sonnen. Oh, I love you. I love you so much. I hope you have a wonderful night at work, day at work for you. I should read comments entirely before I click the button. However, I guess I dressed appropriately. Oh, you don't know how much I love you. Oh. Ooh, big city shopping. That sounds like fun. I would be big city window shopping. That's my kind of fun. Hi, Earl. Earl is wanting to get in on the conversation, y'all. Hi, Ruth Ward. Well, yeah, Ava, food. Isn't that how all of the streams start? Throw in some naughty jokes and then some cats. And yes, I avoided calling them the alternative word for them upon the naughty jokes comment. Oh, Tammy, thank you. You are so loving to the chat. You make my heart melt. I know, you're trying so hard to hit her. Yes, blame it on retrograde. Everything is on retrograde right now. Retrograde's at fault. Well, come here, baby boy. Earl, come here. Hi. I know, honey. Yes, I am on with everybody. Yeah, they're all right here. They say hello. They say hello to you too. Because you're the sassy sis. Tammy's the sweet sis. That's how it works. That was picked long ago. And because, truth is truth. We'll get you. We'll get you. You got that slide on now, and I know it. How the streams getting pushed out to the YouTube world has its algorithm. So does the membership gifting. It's got its own funky algorithm that no one understands except for the coders of YouTube. And I think they just do it out of a sick little joke sometimes. Yeah, they're the only ones who know how they are distributed. I know it's based on like activity and comments and, stuff like that, like how active you are in the chat. But then I do see it go to people that are subscribers, but they've never physically made the live, which is, I'm grateful for that, by the way. I'm not complaining. I love my day crew. I absolutely love all of the replay crew. And I love seeing the comments from everybody on the replay crew. And so that's not the complaint. The complaint is that YouTube does funky stuff. And I am so grateful to have you here. I really am. And you, one of these days, we're going to get you. Get you. I know. He hasn't been here for a hot minute. He's been so busy working. I do still text him. He does still miss you guys. Yeah. Well-ish. I come on after the kiddos go to bed, typically. She's referring to this. She's making a naughty joke about your comment and then trying to pin it back on you. Mm-hmm. That's what she's doing. So no, you didn't say anything bad, honey. Keep going. What are you two doing? Oh, what? You can't have to go potty already. You have to go potty? Oh my gosh. I haven't even gotten it exported yet. I've got to put it on the Palmy drive. Guys, give me 2 seconds. I am sorry, but the Ava must go. It was that prairie chicken and beef. All right. This one, she's going to start her Chewbacca call in a minute if I don't get my tushy moving. You're being the good one tonight. How is that possible? Oh, hi, Shane. How you doing, Shane? Welcome. I'm glad to see you. Shane was here with me last night. He was like a lone ranger until Philip got in here. She's waiting by the back door, y'all. Yes, a train. Okay, now I've got it exported. Now I have to safely eject my media. A professional would have done this already. You have great news? I cannot wait to hear it. It's a secret club, and you have to be willing to receive the face sleep texts from me, like 4 pages deep in a matter of a minute and a half. Okay. All right, guys. I'm all hooked up. You guys are so funny. I love you. All right. I got to put this on, and then I've got a puppy to attend to. I'll be right back.
$1,000. In this case, Mr. Steele had methamphetamine, cocaine, cash, and approximately 130 grams of fentanyl on his person. He is charged with a DF1 and was on bond for a DF1 from June, a DF4 from December, and had a March DM1 warrant for an April 11th failure to appear. There's also 22 lifetime failures to appear and a previous DF3 conviction. The people have very serious community safety concerns given this history and the facts of this case, the fact that he was out on bond in those other two very similarly charged cases. There was a $200 cash bond and a $100 cash bond in those cases, and then picked up this even more serious case combined with these FTAs. We do think that he's both a community safety and flight risk.
So again, that number, please.
75,000 cash or surety. And then the no alcohol, no drugs, no marijuana, monitored sobriety. We'd ask that he not be allowed to leave the state without permission as well.
And Mr. Sheldon.
Your Honor, in this case, we're requesting that the court impose a cash bond of $2,000. Mr. Steele told me that he previously lived in Fort Collins for 10 years, and he's been living in Aurora for the last 2 years. He explained that he does have a way to get to and from court, that he receives food stamps and Medicaid. While we understand that the nature of these charges is quite serious, and Mr. Steele doesn't have the best history, we think that a $75,000 cash or surety bond is unreasonable in this case. So, Your Honor, we are requesting as a $2,000 cash only bond. Thank you.
Okay, the court will order a $50,000 cash surety bond, alternatively a $5,000 cash only bond. Enhanced supervision, monitored sobriety is directed by pretrial services, no alcohol, no illegal drugs, no recreational marijuana. Must obtain permission to leave the state and file a waiver of extradition. Must remain law-abiding at all times. No weapons. You are subject to random UAs. Because you're alleged to have violated a Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1001, which will remain in place until final disposition of your case. Pursuant to this protection order, you shall not harass, molest, intimidate, retaliate against, tamper with, any witness to, or victims of the acts charged. Violation of the protection order may result in you being held in contempt and or the filing of new charges against you for violation of a protection order. Your next hearing date, Mr. Steele, is April 23, 2024 at 8:30 a.m. in courtroom 5C. Is there anything further, Ms. Bacher?
No, Your Honor.
Mr.
Thank you,
Sheldon.
sir.
All right, Mr. Steele, have a good day.
You too. Your Honor, I believe we have Mr. Crofts on the mobile unit.
Thank you. Good morning. Please state your name for the record. Good morning, Mr. Crofts. I'm Magistrate McDonald. This is case number 24 CR 5119. While you were waiting, did you have an opportunity to review the advisement information that was provided to you?
Yes.
Do you have any questions as to your rights at this time?
No.
Right. Ms. Bacher, the people's position on bond.
The people are actually asking for a higher than recommended cash bond. We feel that Mr. Crofts is both a community safety and flight risk in this case. Here he fought with officers while reaching for a knife. He also had meth on his person. The bond application notes that he had 6 active warrants and was already on bond and pretrial supervision. Those warrant and bond cases include a misdemeanor menacing, 3 felony menacing cases, 2 resisting arrest cases, and a DM1. So very similar charges to what he picked up in this case. He had 8 failure to appears in each of those menacing cases with multiple previous probation revocations as well. They are relatively old cases, but still pending revocation. 51 lifetime failures to appear, perhaps one of the highest I've seen. And those are the reasons we think he's both flight and community safety risk. We're asking for the recommended bond conditions, but also no alcohol, no drugs, no marijuana, monitored sobriety with random UAs, that he report to probation and pretrial within 24 hours of release, and that he not possess firearms or weapons.
What are you asking for in terms of a bond?
I think that 500 cash would be appropriate.
And Mr. Sheldon.
Thank you, Your Honor. We are requesting that the court grant Mr. Crofts a $200 cash only bond in this case. Mr. Crofts explained to me that he is homeless, that he doesn't have very much money, but he does have friends and connections with the community who can assist him with posting bond and helping him out in the community and helping him get to court. So, Your Honor, we believe that while the allegations in this case are serious and they do warrant a monetary type bond, the bond recommended by the pretrial services as well as the district attorney are excessive under the circumstances, and ask for the court to instead grant a $200 cash only bond. Thank you.
Right. Well, the court's going to order a $500 cash only bond. I'm going to go with standard supervision. MIPS is authorized. MIPS is mental health counseling and or services, Mr. Croft. It's there for your benefit. If you wish to take advantage of it, that's great. If you don't wish to, that's fine too. The court is not requiring you to participate in the program. You must remain law-abiding at all times. No weapons, no firearms or ammunition. Actually, I'm just going to say no weapons. I don't think it's redundant otherwise, or never mind, just no weapons. Because you're alleged to have violated a Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1001, which will remain in place until final disposition of your case. Pursuant to this protection order, you may not harass, molest, intimidate, retaliate against, tamper with any witness to, or victims of the acts charged. Violation of the protection order may result in you being held in contempt and or the filing of new charges against you for violation of a protection order. Your next hearing date is April 23rd, 2024 at 8:30 a.m. in courtroom 5C. Is there anything further, Ms. Bacher?
Is the court declining to impose any type of monitored sobriety or restraint from drugs and alcohol?
Oh, I apologize. I am intending to include that. Monitored sobriety is directed by pretrial services. No alcohol, no illegal drugs, no recreational marijuana. I will order random UAs as well. Is there anything further, Ms. Bacher?
Just a timeline for which to report to probation or pretrial if the court chooses to impose that.
Okay. I will order that you report to probation and pretrial services within 48 hours. No, pardon me, within 24 hours of your release. And Mr. Shelton.
Nothing from the defense, Your Honor. Thank you.
Good luck, Mr. Cross. Have a good day.
Mr. Svensson, Your Honor.
Good morning, Mr. Svensson. Please state your name for the record.
Pardon me?
Please state your name for the record.
Ryan Swenson.
Good morning. I'm Magistrate McDonald. This is case number 24 CR 5117.
Yeah, the whole like 50s, 40s, FTAs, that is a theme here. Yeah, it's insane. I don't know how they allow that to continue and still trust them.
This is a VRA case. Is the alleged victim present with us in the virtual courtroom? Hearing no one, we will continue. While you were waiting, Mr. Svensson, did you have the opportunity to review the advisement information that was provided to you?
Yes, Your Honor.
Do you have any questions as to your rights at this time?
No, Your Honor.
Right, and Ms. Bacher.
The people are recommending a cash bond or a secured bond. We don't feel PR bond is appropriate. Mr. Svensson was very recently paroled for a burglary and assault case, and in this case is alleged to have been pretty highly intoxicated, trying to fight strangers at a bar, and then assaulted law enforcement when they were called to assist there. We would ask for the recommended bond conditions in addition to no alcohol, drugs, marijuana with monitored sobriety. And I'd ask the court to authorize random BAs as well as UAs with ETG authorized.
Mr. Sheldon.
Thank you, Your Honor. Notwithstanding Mr. Svensson's history, we do believe that personal reconnaissance bond at the high level that is recommended by pretrial services is appropriate here. Mr. Svensson told me that he resides in Platteville, which is in Weld County, and that he's been in the area for approximately 15 years, that he does have family in the area, so he does have substantial ties to this region. He explained that, even though he doesn't live immediately in Fort Collins, he can utilize public transit options like buses to get to and from court. He explained to me that he is employed. He works as a plumber, so he does have these ties of community, and he doesn't have, really much money for the bond, especially the bond is recommended by the district attorney. when people are paroled out of Department of Corrections, we have this notion that they are fixed and they're ready to go, but that is largely not the case. And a lot of people do need some time to adjust, and sometimes that adjustment process is not good. And so I think that this is a case where Mr. Swinson had a little bit of a mix up, and then he, as alleged, fought back with the police. And the while he is arrested on the F4 charge for second degree assault on a police officer, the injuries alleged in the affidavit are not of a grave or serious nature. I believe that the only articulated injury was an abrasion, which is like getting a skinned shin. It is what it is, but the line between resisting arrest and second degree assault is very thin. Basically, anytime that resisting arrest causes an alleged bodily injury of even a slight degree, because Colorado has a very low standard for what constitutes bodily injury, that resisting arrest or obstructing with force converts into a second degree assault. And it's alleged here that that line was crossed, and the allegations are the allegations. But we do believe that a personal reconnaissance bond is appropriate in this case. If the court doesn't want to give a blanket PR bond, we would ask the court either grant a co-signed personal recognizance bond or a low cash bond of $100 to $200. We believe that these are the appropriate bonds for this case and ask the court to adopt the recommendations of pretrial services.
Listen here, Harvey Potter, the wish.com Harry Potter, John Sheldon, the name fits. Yes, there's a very thin line between just resisting arrest or it turning into a felony because it causes injury, and any injury is covered under that. Yeah, that's how it works. It's to deter people from fighting the cops, drunk or not. And this guy's probably a great guy when he's sober. He just can't handle his liquor and he needs to stay the heck out of the bars. And no one thinks that when they're released from jail, they're fixed. That's never been a thing. No one says that. Everything that came out of your mouth was mush right there.
Thank you. I am going to order an $11,000 co-PR bond, enhanced supervision. MIPS is authorized. Mr. Svensson, MIPS is mental health counseling and or services. It is there for your benefit. You can take advantage of the program if you wish to, but you're not required to do so. Do you understand?
Yes, Your Honor.
Right. No monitored sobriety is directed by pretrial services. No alcohol, no illegal drugs, no recreational marijuana, random BAs, random UAs with ETG authorized. You must remain law-abiding at all times. Report to parole and probation within 24 hours of your release. Because you're alleged to have violated a Title 18 charge, you are subject to a mandatory protection order, which will remain in place until final disposition of your case. Pursuant to this protection order, you may not harass, molest, intimidate, retaliate against, tamper with, any witness to, or victim of the acts charged. Violation of the protection order may result in you being held in contempt or otherwise in the filing of new charges against you for violation of a protection order. Your next hearing date is April 29, 2024 at 8:30 a.m. in courtroom 3C. Is there anything further, Ms. Bacher?
We are asking for a no contact order with the alleged victim.
Okay, and on that specific topic, Mr. Sheldon, your response?
Yeah, we object to a no contact order in this case. I think that the standard mandatory protection order is sufficient. And the reason behind this is that this isn't just a normal assault case between two private citizens. The alleged victims in this case are peace officers. They are members of the community. They're officers of our society. And if Mr. Swinson is, God forbid, pulled over or have subjected to a consensual contact by law enforcement who have the prerogative of contacting members of our community, Mr. Swinson is going to be put into a place where he is going to be inherently violating the no contact order. I think that it's highly inappropriate. It's extraordinarily rare that a no contact order is issued in a case involving law enforcement. It's completely antithetical, and it would honestly, not only compromise the ability for Fort Collins Police Services to have, carry out its mandate, being able to have, free communication with the citizens of this community, but it would put Mr. Swinson in a horrible position where if he's pulled over by one of these officers, he's either going to be in violation of the no contact order, or he's going to be coerced by the circumstances and, heaven forbid, flee the scene to avoid the no contact order. Because technically, if we're going to put the, legal analysis into play, it'd be better to, be committing the M2 flight from an officer obstructing police than it would be to commit the M1 mandatory arrest for having, contact with the police officer during that traffic stop. So we would ask the court not impose a no contact order in this case. It simply makes no sense. Thank you.
So, Mr. Sheldon, are you suggesting that the court should interpret the statutes with common sense?
I would encourage the court to approach this with common sense.
That was a bit of irony there. I was just being cute, or failing to do so, I should say. What I'm going to do is I'm going to order that there will be a no contact order with a 50-yard distance when Officer Tinsley is off duty. As to when on duty, it'll be simply a no harassing contact. Is there anything further, Ms. Bacher?
No, Your Honor.
Anything further, Mr. Sheldon?
No, Your Honor, thank you.
All right, so that return date, Mr. Svensson, is April 29, 2024, 8:30 a.m., courtroom 3C. Good luck.
Thank you, Your Honor.
Mr. Snyder, Your Honor.
Good morning. Please state your name for the record.
Cody Schneider.
Good morning, Mr. Schneider. I am Magistrate McDonald. This is case number 24 CR 5122. This is a VRA case. Is the alleged victim with us present in the virtual courtroom? And hearing no one, I will continue. While you were waiting, Mr. Schneider, did you have an opportunity to review the advisement information that was provided to you?
No.
Okay. Mr. Sheldon, are you in a position where you can waive formal advisement at this time?
Yes, Your Honor, I spoke with Mr. Schneider at booking yesterday. He can waive formal advisement.
Thank you. And Ms. Bacher, the people's position on bond.
The people are asking for a $350 to $500 cash bond. Mr. Schneider has extensive criminal history, but also extensive history of failures to appear. He's on parole for menacing when he committed this menacing, which is very highly concerning. I would ask for enhanced supervision, the mandatory restraining order, that he remain law-abiding, report to parole and pretrial within 24 hours, and not have contact with the alleged victims.
Mr. Sheldon.
Your Honor, I'd like to state for the record, it is actually a conspiracy to commit menacing.
Mr.
Just
Schneider,
as
I am
friends.
begging you to not say anything in court right now. I got this under control. We had a nice conversation yesterday. I know how your thoughts are on this case, and my job is to tell the judge. So, Your Honor, we're requesting that the court grant Mr. Schneider a personal recognizance bond in this case, or in the alternative, a low cash value bond of $100. The allegations in this case are serious. However, they are simply allegations. Mr. Schneider has not even been formally charged with these offenses. He explained to me that he has been homeless for the most part of the last 10 years and that he doesn't have any money for bond. We believe that a personal reconnaissance bond with, loaded down with intensive supervision and non-monetary conditions of bond would be sufficient to provide for the community's safety. He is on parole, as the district attorney noted. That can be that can be taken as a bad thing, but it can also be taken as a good thing. It means that he's going to be under supervision. And typically when somebody's arrested on felony charges while they're on parole looks into it and they follow up on that. So it's not like Mr. Schneider is just going to be cut loose anytime soon. I think that a personal reconnaissance bond in this case is justified under those circumstances, as parole will most certainly take some type of action to correct this behavior.
Yes, because it's working so well up till now. I mean, since he's been on parole, he hasn't done anything menacing other than what he did.
So, Your Honor, with that, we ask the court grant Mr. Schneider a personal reconnaissance bond or a cash value bond at $100.
Thank you. I will order a $250 cash only bond, enhanced supervision. MIPS is authorized. Mr. Schneider, MIPS is mental health counseling and or services. It's there for your benefit. You may participate in the program if you wish. I'm not requiring you to do so, so there's no heartburn from the court if you don't participate. It's there for your benefit. Do you understand?
Yeah.
Okay. Monitored sobriety is directed by pretrial services. No alcohol, no illegal drugs, no recreational marijuana. You must remain law-abiding at all times. You're to report to parole within 24 hours of your release. Because you're alleged to have violated the Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1-1001 that will remain in place until final disposition of your case. Pursuant to this protection order, you shall not harass, molest, intimidate, retaliate against, tamper with any witness to, or victims of the acts charged. Violation of the protection order may result in you being held in contempt and or the filing of new charges against you for violation of a protection order. Your next hearing date is April 23rd, 2024 at 8:30 a.m. in courtroom 4B. I will order a no contact between the defendant and the alleged victim, Gary Stanley, with a 50-yard distance restriction. Is there anything further, Ms. Bacher?
No, Your Honor.
Is there anything further, Mr. Sheldon?
No, Your Honor, thank you.
All right, Mr. Schneider, good luck.
Mr.
I did rather enjoy the attorney when the defendant started speaking, and Attorney Sheldon was like, I am begging you. I've got this. Yeah, that tickled me just a little.
Stewart, Your Honor.
Good morning. Please state your name for the record.
David Stewart.
Good morning, Mr. Stewart. I am Magistrate McDonald. This is case number 24 CR 5121. And this is a VRA case. Is the alleged victim present with us in the virtual courtroom? And hearing no one, we will continue. Mr. Stewart, while you were waiting, did you have an opportunity to read the advisement information that was provided to you?
That's how we measure.
Yes, Your Honor.
Do you have any questions as to your rights at this time?
No, Your Honor.
Very good. Ms. Bacher, the people's position on bond.
The people do not feel a PR bond is appropriate. We would note that he is on parole in multiple cases, including a domestic violence case. He's now being charged with a new felony domestic violence case. He's got pretty extremely extensive criminal history and failure to appear history at 40 lifetime failures to appear. We would be asking for $250 cash with the recommended conditions.
And Mr. Sheldon.
Your Honor, notwithstanding the seriousness of the allegations in this case, we do believe that the personal reconnaissance bond of $11,000 as recommended by pretrial services is appropriate here. Mr. Stewart explained to me that he does live in Colorado Springs, but he would definitely be able to get to and from court in Fort Collins. He explained that he is self-employed, that he receives Medicaid. He has 3 children, 2 of whom are minors, and for whom he provides financially, and that those children do reside in Colorado. The prosecution mentioned this, and it's included in the bond application that he has 40 failures to appear. That's a lot of failures to appear, but I want to add some context to these failures to appear. I did some research on data access to see when these happened, and none of them happened in the last 5 years. And Mr. Stewart has had some serious cases, but in the last 5 years, but he has not had any failures to appear. He's had a very good history of attending court for these serious cases. So, Your Honor, while the 40 failures to appear is a striking number, that's a lifetime total, and it's not with that's the entire range of his life and his history. But none of those failures to appear have happened in recent history.
Is that truly helpful? Your Honor, I recognize that my client has 40 lifetime failures to appear, but in the last 5 years, he's had some serious charges against him, and he showed up. I'm serious, Your Honor, that the charges against him, they're awful, horrendous. You wouldn't believe the things that he's done, and he still came to court. Like, I don't think that's truly helpful.
Which demonstrates that he has, he can be relied upon and trusted to appear in court, given that he has ties to the state of Colorado and that he has the ability to appear in court. We believe that a personal recognizance bond in this case is justified, and we ask the court to engage in the non-monetary conditions of bond to address its concerns. Thank you.
Colorado does this thing where they try to set bond and bail amounts in realistic amounts. Like, they know the likelihood that people are ever going to be able to come up with $50,000 to get out of jail when they're homeless and living on the street. That's not going to happen. So they have transitioned to this like realistic expectation of bail and bond amounts. And it's kind of a science project at this moment. You know, I personally believe it's to the detriment of their citizens, but we won't know how it truly affects things for years. It's going to be a couple decades of going through this before we'll truly know the effects that it has on its people.
Thank you. I will order an $11,000 co-PR bond, enhanced supervision. MIPS is authorized. MIPS is mental health counseling and or services. It's there for your benefit, Mr. Stewart. You can participate in the program or not. It's up to you. I'm not going to require that you do it, but it's there for your benefit if you wish to take advantage of it. You understand?
Yes, sir.
You must remain law-abiding at all times. Report to parole within 24 hours of your release. You are subject, because you're alleged to have violated a Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1-1001 that will remain in place until final disposition of your case. Pursuant to that protection order, you shall not harass, molest, intimidate, retaliate against, tamper with any witness to or victims of the acts charged. Violation of the protection order may result in you being held in contempt or the filing of new charges against you for violation of a protection order. Because you're being charged with a crime that is alleged to be an act of domestic violence, it's a condition of your bond and a condition of the protection order that you neither possess nor receive any firearms or ammunition during the period of the protection order. If you have firearms or ammunition, you're required to relinquish them within 24 hours of your release. You'll be provided a packet of information that addresses the relinquishment protocol. You need to fill it out and return it to the court within 7 days. Failure to return it to the court within the 7-day period and or failure to relinquish weapons and or firearms within the 24-hour period may result in new charges being filed against you, may result in you being held in contempt, and or may result in you having your bond revoked. Your next hearing date is April 22nd of 2024 at 8:30 a.m. in courtroom 3B. I will order a no contact order between you and the alleged victim, Scarlett Missner. Mr. Sheldon, is there need to authorize a one-time civil standby? Do they cohabitate?
I'm not sure, Mr. Stewart. Do you guys live together?
We have property, Andy, in the same dwelling. Yeah.
So yeah, we would request a civil standby, Your Honor.
Okay, so I will order a one-time civil standby. Is there anything else, Ms. Bacher?
Is the court going to issue an exclusion zone?
50 yards. Thank you for asking. Anything else, Mr. Sheldon?
Your Honor, we would just like to set the next hearing for a modification of bond.
So noted.
Thank you.
Mr. Sheldon. Good luck, Mr. Stewart. Have a good day.
Mr. Marshall, Your Honor. Hello,
Good morning. Please state your name for the record.
Brandon Marshall.
Good morning, Mr. Marshall. I'm Magistrate McDonald. This is case number 24M.
How are you today?
I'm good. How are you?
Doing better.
All right. Case number 24M5092. And Mr. Marshall, while you were waiting, did you have an opportunity to review the advisement information that was provided to you?
Yes, I did.
Do you have any questions as to your rights at this time?
No, sir.
Right. Ms. Bacher, the people's position on bond.
People agree with the recommended bond and bond conditions, given the criminal history in Colorado and out of state, that he's on pretrial supervision and bond in 7 other cases already, and the failure to appear history.
Mr. Sheldon.
Your Honor, we will be requesting a personal recognizance bond, and it's the circumstances I think warrant giving Mr. Marshall a personal recognizance bond because he is under competency restoration treatment right now. His treatment is based on an out of custody basis. According to a competency liaison report filed in one of his existing cases on April 3rd, 2024, states that Mr. Marshall is receiving restoration services through Summit Stone Health Partners Competency Support Services. Through this program, he's getting medication management, therapy, and case management. Your Honor, the reason why we're asking for a PR bond so that way he can engage with these services is that if Mr. Marshall is reduced to in custody, then new orders will have to be made for restoration. The restoration would have to be completed in custody on an inpatient basis, which could cause significant delay and potential backsliding, whereas any progress that he may have made while engaging with these pretrial with competency restoration could be erased and he'd have to start all the way over again. Your Honor, in addition to these things, he explained that he doesn't have really any money to post, especially for the recommended bond amount. He explained to me that he has an arrangement to have surgery on a hernia on the 19th. So, Your Honor, we are requesting that the court grant him a personal recognizance bond in this case. Thank you.
The court will adopt the recommended pretrial services bond recommendation of $125 cash or at $1,250 cash surety. The court notes that under the circumstances, this is not the type of innocuous violation of a protection order that sometimes merits a PR. And together notes the CPAT score of the category 4 and score of 18 in making that determination. MIPS is authorized, Mr. Marshall. MIPS is mental health counseling and or services. It's there for your benefit, but you don't have to take advantage of it if you don't want to. So there's no requirement to participate, but it's there if you wish to. Monitored sobriety is directed by pretrial services. No alcohol, no illegal drugs, no recreational marijuana. You must remain law-abiding at all times. Because you're alleged to have violated a Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1-1001, which will remain in place until final disposition of your case. Pursuant to that protection order, you shall not harass, molest, intimidate, retaliate against, tamper with any witness to, or victims of the acts charged. Violation of the protection order may result in you being held in contempt and or the filing of new charges against you for violation of a protection order. Your next hearing date is April 22nd of 2024 at 1:30 p.m. in courtroom 5D. Ms. Bacher, is the defendant currently under a no contact order with the alleged victim, in this case, Cassandra Larson?
Just one moment.
Since this is a VPO, I kind of assume that that's the case.
I believe so, yes.
All right. So are the people content with leaving the protection order in the underlying case as opposed to adding one in the instant matter?
I'll defer to the court. I go back and forth. I realize there's already one in place. However, I mean, obviously it's already being violated. It can also affect the number of charges or seriousness of future cases, depending on how many protection orders are in place.
Well, I will simply not order it. And the concern is not based upon future cases so much as it's based upon confusion. Because if there's modification in the initial case and there's no modification in the subsequent case, it creates scenarios where sometimes defendants are in a position where they think that they're acting in a legal fashion, but they're not. And all things being equal, I think that the existence of the no contact as it already stands is enough. Is there anything further, Ms. Bacher?
I'm just asking the court to authorize random UAs. I'm not sure if the court said that or not, but I would request that.
I did not, but I will so order. And I think I said the return date, but I'll say it again, April 22nd, 2024 at 1:30 p.m. in courtroom 5D. Is there anything further, Mr. Sheldon?
Your Honor, thank you.
All right, Mr. Marshall, best of luck. Have a good day.
Your Honor, was there a supervision level?
Standard, please.
Thank you. Mr. Lang, Your Honor.
Good morning.
Hello,
Please state your name.
Jeffrey Lang.
All right, Mr. Lang, I'm Magistrate McDonald. This is case number 24 CR 5106. This is a VRA case. Is the alleged victim with us present in the virtual courtroom?
You can only hear out of one ear.
Mr. Lang, he's not asking you, he's asking just the courtroom.
Oh, sorry.
It's all good. I will try to speak up a little bit to the extent that that helps. I'm not hearing any participation from the alleged victim, so we will continue. Mr. Lang, did you have an opportunity to review the advisement information that was provided to you?
Yeah.
Do you have any questions as to your rights?
No.
Right. Ms. Bacher, the people's position on bond?
Thank you, Your Honor. I know the CPAT was not completed, so we don't have a score. So it's always a little tough to recommend. It doesn't appear that that was due to Mr. Lang being super combative or uncooperative, though. It notes that he wanted to talk to his parents and lawyer first, get some advice probably. I do think that based on the history or lack thereof and the information we do have, I guess, I think a co-PR bond would be appropriate. I would ask for the recommended checked conditions in the bond application as well as enhanced supervision.
And Ms. Bacher, what number are you looking for the co-PR bond?
I'll defer to the court on a number. I think somewhere in the range of $1,000 would be appropriate.
Mr. Sheldon.
Your Honor, we are requesting that the court grant Mr. Lang a straight PR bond without a cosigner requirement. This scenario went down while Mr. Lang was apprehended on a intoxication hold, and it was a very unfortunate. The allegations in this case are very unfortunate, and so we believe that this is a case that would warrant a PR bond. The prosecution has recommended a co-PR bond, but we believe that Mr. Lang is sufficiently responsible to sign himself out of jail. He explained to me that he lives in Fort Collins. He has been in Fort Collins since May of 2023. He has a prior brain injury, and he can only hear out of one of his ears. He explained to me that he is employed in the community, working at a restaurant. He is originally from Colorado. He has family in Highlands Ranch, just south of Denver. He does have a rental in Fort Collins, so he does have significant ties to the community, and he has been in contact with his parents. So we believe that a personal conscience bond in this case is warranted based on the fact that he doesn't have really any criminal history, and that the one reported failure to appear is from several years ago. So thank you, Your Honor.
Thank you. I will order a $1,000 co-PR bond, standard supervision. MIPS is authorized. MIPS is mental health counseling and or services. It's there for your benefit. If you wish to participate, great. If you don't, you're not required to do so. Do you understand that, Mr. Lang?
It's like I'm getting offered mental health advisement.
Exactly. But you
Okay.
don't have to do it. It's there for
Do
you.
I
if
get
you want it.
benefits from going to do it other than just learning?
I would submit that the benefits are intrinsic, but I can't tell you that it would help your court process. It's just for you
Okay.
to do better.
Okay.
Moderate sobriety is directed by pretrial services. No alcohol, no recreational marijuana, no illegal drugs. You must remain law abiding at all times.
She ceases to exist for the time being. The only way that's going to change is if a local judge changes the no contact provision. Judge, I am going to be asking for permission to travel out of state with a waiver of extradition. I understand that Mr. Bryant will have to appear in person for his next court appearance, but it's my understanding that he is now a resident of North Carolina. Certainly, I think it's best for everyone that my client be permitted to return to his home state. Thank you.
Thank you, Ms. Goldstein. Mr. Bryant, having heard the arguments of counsel, having read the documentation that accompanied your arrest, noting that you are a CPAT level 1, which tells me there's a good likelihood of your being successful while on bail and bond, and having taken input from the victim through the district attorney, the court finds that bond in this matter is appropriately set as a $1,000 personal recognizance bond. That means that you will be able to sign out of the jail today without paying any money. Okay? In addition to bond set at that amount, you will not have pretrial supervision. You are to remain law-abiding while on bail and bond, and you will sign a waiver of extradition. Mr. Bryant, a waiver of extradition is a document that says if you leave Colorado and you're picked up in another state, it won't be up to a judge in that state to determine whether you'll be returned to Colorado. But between here and there, you are free to travel wherever you would like, okay? So you can return to North Carolina. The court is going to issue a protection order. This protection order is a condition of bail and bond. If you violate it, you will find yourself subject to additional criminal charges. Terms are that you not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. You're to stay away from the home of the victim and any location where the victim is or is likely to be found by at least 50 yards. You're to refrain from contacting the victim either directly or indirectly. Indirectly includes text messaging, social media, or through a third person. As your attorney just said, Mr. Bryant, a third party cannot contact the victim on your behalf. If they do, you will be in violation of this protection order. And I would not want to be in your shoes, getting arrested again and having to try and argue that you didn't have any control over what a third person said. So if I were you, I would take some affirmative action and make sure that nobody is contacting the victim and save yourself an awful lot of trouble, and you won't get hauled back here from North Carolina. You will not possess, purchase, or control firearms, ammunition, or other deadly weapons. You will have to complete a firearm relinquishment affidavit before being released, and you are not to possess or consume alcoholic beverages or other controlled substances. Mr. Bryant, are you a veteran or an active duty member of the United States military?
No, sir.
All right. Do you wish to be represented by the public defender?
Due to the alacrity and unclear verbiage of Ms. Goldstein, I guess yesterday, I'm going to go pro se and represent myself because
that is your right to represent yourself.
Yes, sir.
Should you change your mind, as soon as possible, I want you to submit an application to the court requesting representation by the public defender. You can find those applications on the public defender's website. Again, if you change your mind and wish to have their representation, as soon as you make that decision, submit that application to the court. Otherwise, public defender is not aware of your case. Your next court date is tomorrow, April 15, 2024, 2 p.m., courtroom A. Again, that's April 15, 2024, 2 p.m., courtroom A. Mr. Bryant, Judge Bo Zrep will be hearing the case tomorrow. He will expect you to be there in person. So you're going to have to spend the night in Delta and show up tomorrow at 2 p.m. So, Mr. Bryant, through counsel, we waive further reading and advisement. We set bail and bond. We issued a protection order and talked about its terms. We discussed representation by counsel, and I set your next court date. Regarding bail and bond, do you have any questions or concerns for me?
Yes, sir, Your Honor. I spent the last $2,000 on the rental truck that's been sitting there for 2 days with partial belongings that's been loaded up. If I miss my date getting back to North Carolina, they're going to add to it. And if you could please just make it where I could appear through a teleprompt or whatever, or please, I throw myself at the mercy of the court I have no money, and I'm based off of the amount of time that I've got to get back with that truck. And I will appear. I'm good for it. Everybody knows me. Samantha even informed the officer she did not want me arrested. And they did not want to arrest me. I'm good for my word. It's an
Mr.
honor.
Bryant, Mr. Bryant, I hear you. I appreciate your concerns. However, your next court date is set by the local court, and I can't change that, and I cannot roll it over to a virtual hearing. Okay? So it is not going to change. You are set for tomorrow at 2 p.m. And that is where we're at, and it cannot be amended today. All right? Ms. Goldstein, anything additional from you?
No, thank you, Judge.
All right. Mr. Doherty?
No, Your Honor, thank you.
Okay.
I must say, I love the pink handcuffs. They really make the outfit pop.
Good luck to you, Mr. Bryant.
Judge, I show that we have 2 left from Delta, Harrison and Worley.
Oh, thank you.
Your Honor, Mr. Nathan Worley.
Okay. So this will be the matter of Nathan Worley, 24 CR 5008. We have Mr. Doherty for the people, Ms. Goldstein for defendant. Ms. Goldstein, were you able to meet with your client in this matter?
Judge, I did speak with Mr. Worley yesterday. We would waive Rule 5 advisement. Thank you.
Okay, thank you. Mr. Doherty, your comments on bail and bond, please.
Your Honor, I would note in this case, the pretrial services report places Mr. Worley at a category 4. His failure to appear history is significant, 52 in the last 5 years. A chunk of those are felony cases. Really, without going too much more into it, Your Honor, we would be objecting to a PR bond. I lead up to the court whether a cash surety bond at whatever level is appropriate. Judge Europe typically doesn't do cash surety bonds, does cash or PR. That's his policy, but I'll leave it up to the court of what level is appropriate on this. I would ask for a standard protection order otherwise. Thank you.
Okay. Thank you, Mr. Doherty. Ms. Goldstein, your comments on bail and bond, please.
Thank you, Judge. Judge, my client has been staying with a friend in Delta. I understand the prosecutor's concerns regarding my client's ability to appear for court. Certainly, I think my client has been struggling with that, although he tells me that a majority of his FTAs occurred because of inadvertence on his part. So I would ask for a PR bond for this property crime. Alternatively, I'd ask the court or suggest to the court that $150 cash only bond. Thank you.
Okay. Thank you, Ms. Goldstein. Mr. Worley, having heard the arguments of counsel, having read the documentation that accompanied your arrest, noting that you are a CPAT level 4, noting the extraordinary numbers of failures to appear, the court does not find that a personal recognizance bond is appropriate. Incorporating the local rules and practices in a matter like this, bond will be set as a $5,000 cash only bond. In addition to bond set at that amount, you are to remain law abiding while on bail and bond. You're not to leave the state of Colorado without court permission. If you do need to leave the state, I want you to get permission from the court at least 2 weeks in advance. You will sign a waiver of extradition. Waiver of extradition is a document that says if you leave Colorado and you're arrested in another state, it won't be up to a judge in that state to determine whether you'll be returned to Colorado. And you are not to drive without a valid driver's license. In addition to bonds set at that amount, with those conditions, the court will also issue a protection order. Excuse me. Before I go any further, should you be released, you are to have enhanced pretrial supervision. That is enhanced pretrial supervision through Delta County Pretrial Services. In addition to bonds set at that amount, and with those conditions, the court will also issue a protection order. This protection order is a condition of bail and bond. Should you violate it, you will find yourself subject to additional criminal charges. Terms are that you not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. You're to stay away from the victim in any location where the victim is or is likely to be found by 50 yards. You're not to contact the victim either directly or indirectly. And you are not to possess, purchase, or control firearms, ammunition, or other deadly weapons. Mr. Worley, are you a veteran or an active duty member of the United States military?
Oh,
Do you wish to be represented by the public defender in this matter?
yes.
Yep. If you're able to post bond within 7 days of leaving the detention center, if not sooner, I want you to submit an application to the court requesting representation by the public defender. So long as you remain incarcerated, a public defender will be assigned to your case. Your next court date is April 15, 2024, 2 p.m., courtroom 1. Again, that's April 15, 2024, 2 p.m., courtroom 1. So, Mr. Worley, through counsel, we waive further reading and advisement. We set bail and bond. We issued a protection order and talked about its terms. We discussed representation by counsel, and I set your next court date. Regarding bail and bond, do you have any questions or concerns for me?
Yeah, what about the cops that stole personal information being related to this case? I want to press charges against all of them involved.
Mr. Worley, that's something that you can take up with your attorney, but we will not be going over that today. Ms. Goldstein, anything additional from you?
Mr. Worley, I would just tell you that because it appears unlikely you will be posting bond, the public defender will be with you tomorrow in court, and certainly you can share your concerns with your public defender about wanting to press charges. I wish you the best of luck, sir.
Mr. Doherty, anything additional from you?
No, Your Honor. Thank you.
All right. Good luck to you, Mr. Worley.
Mr. Royce Harrison, Your Honor.
Royce Harrison, 24M68. We have Mr. Doherty for the people, Ms. Goldstein for defendant. Ms. Goldstein, were you able to meet with your client in this matter?
I was, Judge. We would waive Rule 5 advisement.
Okay, thank you. Mr. Doherty, your comments on bail and bond, please.
Yes, Your Honor, this is a property crime based on him being a Category 1, and I'm not viewing any prior FTAs or criminal history. I have no objection to a PR bond. I would just ask for a standard protection order at this time. Thank you.
Ms. Goldstein, your comments on bail and bond, please.
No objection, Judge. Thank you.
All right. Mr. Harrison, having heard the arguments of counsel, having read the documentation that accompanied your arrest, and considering that you are a CPAT level 1, the court is willing to set bond in this matter as a $1,500 personal recognizance bond. That means that you will not have to pay any money today to leave the detention center. You will not be ordered to pretrial supervision. You are to remain law-abiding while on bail and bond. And additionally, because a firearm was involved in this matter, you are ordered to relinquish all firearms within 48 hours, and you will have to complete a firearm relinquishment affidavit prior to leaving the detention center. In addition to bonds set at that amount and with those conditions, Mr. Harrison, the court will also issue a protection order. This protection order is a condition of bail and bond. If you violate it, you will find yourself subject to additional criminal charges, and your bond may be revoked. Terms are that you not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. You are to stay away from the home of the victim and any location where the victim is or is likely to be found. Specifically, you are to stay 50 yards away from the address of, I don't care if a friend of a family says you can be there, the court is telling you to stay 50 yards away from that address at all times. You will not contact the victim either directly or indirectly. Indirectly includes text messaging, social media, or through a third person. You are not to possess, purchase, or control firearms, ammunition, or other deadly weapons. And again, you will complete a firearm relinquishment affidavit prior to leaving the detention center. I do not condone irresponsible gun use, and in this case, you will have to give up your firearms until a court decides otherwise. Finally, you are not to possess or consume alcoholic beverages or other controlled substances. Mr. Harrison, are you a veteran or an active duty member of the United States military?
No, sir.
All right. So you shaking your head no. Do you wish to be represented by the public defender in this matter? Right. So Mr. Harrison, you have the right to have an attorney appointed by the court to represent you if you cannot afford counsel. That is not a decision that you have to make today. However, if you want a public defender to represent you within 7 days of leaving the detention center, if not sooner, I need you to submit an application to the court requesting representation by the public defender. You can find those applications on the Public Defender's website. What's important for you to know is that if you don't submit an application, there won't be an attorney there to represent you in the future. They won't know about your case. All right? It's your decision to make, but if you do make it, submit that application to the court as soon as you've made your decision. Your next court date is April 15, 2024, 2 p.m., courtroom A. Again, that's April 15, 2024, 2 p.m., courtroom A. So, Mr. Harrison, through counsel, we waive further reading and advisement. We set bail and bond. We issued a protection order and talked about its terms. We discussed representation by counsel, and I set your next court date. Regarding bail and bond, do you have any questions or concerns for me?
Yes, sir. For the PR, I would be released today, right?
That's right. You don't have to pay any money today. I'm going to take you at your word that you'll show up to your next court date. If you don't show up, then you're going to have to forfeit that money.
Yes, sir.
All right. Ms. Goldstein, anything additional from you?
Just briefly, Judge. So, Mr. Harrison, you're going to be released today. You've got court tomorrow at 2 p.m. You need to be personally present. If you have access to the internet, you can go online today to Colorado State Public Defenders to fill out an application. Alternatively, it's more than likely that there's a public defender who's going to be in the courtroom tomorrow, and you can speak with them and hopefully get an application from the court clerk's office. I wish you the best of luck, sir.
Thank you.
Mr. Doherty?
Nothing from the people, Your Honor.
All right. Good luck to you, Mr. Harrison. Deputy over there in Delta, thank you for keeping things running smoothly today. I appreciate it.
Yeah, she can't, well, the court can't force him to get an attorney, but they can strongly suggest it and suggest it again and encourage him to fill out an application.
Of course, thank you, Your Honor.
All right. That is going to wrap us up. Mr. Doherty, Ms. Goldstein, thank you both for the arguments and the professionalism today. It's really appreciated. And we are going to be adjourned. Please enjoy the rest of your weekend.
You too.
Judge,
Thank you.
All right, great. We're at 10:45, so we'll go ahead and call the Eric Hawley matter. This is out of Grand County, and it's 24M5008. So, Mr. Hawley, I'm Magistrate Herringer. We are here to set a bond with regard to your recent arrest. Because you're in custody, you automatically qualify for a court-appointed attorney. We have Ms. Garcin present. She's an attorney. She can represent you at this hearing. She would argue bond on your behalf and would do so at no cost to you. Do you wish to have her representation today?
Yes, please.
Okay, so ordered. Ms. Garcin, have you had a chance to speak with Mr. Hawley, and if so, can you waive advisement?
Your Honor, I did speak with Mr. Hawley. I'll waive formal reading and advisement.
Thank you. All right, Ms. Dowdo, if you can tell me if you've had victim contact and then what you're asking for in terms of bond and a protection order.
Thank you, Judge. And for bond, we're requesting a $750 PR bond. We did have contact with the named victim. She is requesting a full no contact protection order at this time, and the people would second that request. Thank you.
Okay. So, give me a second. So I know that the parties are related. Is this Mr. Hawley's residence as well as the victim's residence?
Yes, Your Honor.
Judge, my understanding is that they all live there. I think their niece and uncle is my understanding.
That's correct.
Yeah.
It's my
cousin.
It's my father and my cousin's daughter.
Okay. All right. All right, Ms. Garcin, do you wish to be heard?
Your Honor, I do. Thank you. We would join the request for a $750 PR bond. As to the protection order, I'm asking the court to consider just a box one protection order shall not harass, retaliate conditions. As the court can see, given the nature of the allegations, what we have here is being investigated as negligent or reckless behavior. I think that is a very important distinction as opposed to a knowingly or intentional use of any type of a weapon or knife. Mr. Hawley does live with his father in this place, and Miss Eleanor Hawley, due to having some behavioral issues out of state, that is why Mr. Eric Hawley and his father took her in to try and give her another kind of a second chance, a better place to get away from where she was having some difficulties. Eric Hawley is a caretaker approved by the state for his father. His only income is that income and that residence. He earns about $400 a month. So he is not in a position, he doesn't have another place to live at this time, nor is there another caretaker set up for his father. So I do think that that is makes things much more difficult if we are talking about a full no contact order. So I am asking the court to set the $750 with a box 1 protection.
Okay, well, I'm going to do a no contact for now. I'm going to add some terms to it. The return date on this is going to be on Tuesday, so we just have a couple of days. I'll authorize a civil standby and a few other things that hopefully will kind of mitigate the inconvenience to Mr. Hawley and to Mr. Hawley's father. All right, bond will be set at $750. Personal reconnaissance bond. Condition of the bond will be defendant is to comply with the protection order. The protection order in this case will read as follows. You're not to harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the act you're charged with committing. You're to vacate the home of the victim, stay away from the home of the victim, and stay away from any location the victim's likely to be found. You refrain from contacting or directly and indirectly communicating with the victim or witness. You're not, or just the victim, not the witnesses. You're not to possess, purchase, or control a firearm or other weapon. You're not to possess or purchase any ammunition. Under box 8, I'm going to mark that the defendant may return to the home for purposes of caring for his father when the victim is not present. And I'm also going to mark that, and I'm also going to approve a civil standby.
Sir, I have nowhere else to go. I literally moved here. I would be literally living under a bridge and then going to help my father. There's one other thing. I have a staph infection in my right hand. I have been in the ER yesterday, and also they told me if it got worse, I would have to be probably admitted into the hospital today if it got worse, and it has. I did not explain this I did not know this was going to be an issue when I spoke with my lawyer yesterday. But basically, they told me I have to go to the emergency room directly after this, and I may be admitted overnight. But and also, I don't have any other place to live in Kremling. That's where we're at. I don't know anybody. So if I was to care for my father, like I'm supposed to, I can't just go stay under a bridge and then expect to care for my father. You know what I'm saying?
Well, the guy on one of the previous dockets, he had a hernia that he had to get taken care of. So, I don't know. Your staph infection, his hernia, y'all got problems.
Yeah.
I do not have an issue with her. Like my lawyer said, she has some mental issues.
Mr. Hawley, at this point, I'm going to interject that I would recommend that you stop it there.
Okay, thank you.
So, yeah, Mr. Hawley, I understand the difficulties here, but I'm in a difficult position also because I have a child victim, and she's asking for no contact, and for me to put to go against that, when somebody doesn't want contact with the person who's alleged to have perpetrated against them, and you're presumed innocent, and I'm not saying that you actually did this, but it's just in terms of what I need to do with the protection order. I generally do not issue protection orders that allow somebody to have contact with somebody who's an alleged victim who's saying they don't want to have contact with the person.
Well, I would not be having contact with her. I would be staying in my room like I usually do.
Yeah, and so the way this reads is that you can return to the house when she's not there.
Okay.
If the family has somewhere else for her to go where she can be, where she can stay, and she's willing to go there voluntarily so that you can return and take care of your father, that's fine. You can't kick her out. You don't, because that would be in violation of the protection order, but
I would,
if something can be arranged where she can go stay somewhere, especially for the next couple of days until you can go to court, and you can return to the property, because you're allowed to go there when she's not there.
okay,
But what I don't want is, I don't want something where, she's passing you in the hallway and all of a sudden you guys are having, there's an argument and it flares out of control, and then the cops are back there again and you're back in custody and you've got your thing with your hand, and it's good. Everything just gets more and more complicated. So
I understand that.
yeah, so we're gonna be conservative about it at this point. Maybe when you go back to court on the 16th, the court will be able to address it. We'll make a note that you wish to address the protection order at the first available hearing, and so the court will know that, and the DA will be on notice that you wish to do that. But at least at this point, I can't, in good conscience, order that you're allowed to have contact with somebody that doesn't want to have contact with you when they're a child and an alleged victim. So
I understand.
okay. All right, so Mr. Holly will go back to court on the 16th, as I said. That will be at 8:45 in Division 2, Grand County. So, Mr. Holly, if you were to violate that protection order, you could have a new criminal charge of violation of protection order, be placed back in jail. If you were to violate any condition of your bond can be revoked and you could be returned to custody. If you fail to show up for court on your bond, you can have a new criminal charge of violation of bail bond conditions. Sir, do you understand all that?
Yes, sir.
And the last thing I will tell you is that the only person who can modify your bond conditions is the presiding judge. So even if everybody in the family agrees, hey, it's okay for you to be here while she's here, even if she agrees, that's not okay. You need to have permission of the judge. Otherwise, if the cops show up, you're going to jail. Okay?
Understood.
All right. And since you're getting out of custody, you'll no longer automatically qualify for a court-appointed attorney. If you wish to be represented by the public defender, you can apply through their regional office, which is in Steamboat Springs. You can also apply through the state public defender website. If you're able to hire your own counsel, which it sounds like you're probably not, but if you are, you have a right to do that also. Okay?
Okay.
All right. Anything else from anybody as it relates to Mr. Holly?
Thank you.
No, sir. Thank you.
Okay, Mr. Holly, please abide by your protection order and show up for court. Okay?
Thank you.
Ms. Dowdo, thank you for your appearance. Grand County, thank you for making Mr. Holly available. I'll have that protection order to you shortly. And we'll be in recess till we take up the 12th at 11:15.
And I am willing to wager all of my banjo picks that protection order is going to be violated. I'm almost certain of it. That poor girl, the whole family is going to say, oh, just don't worry about him. He'll stay in his room. And then she's just going to be invalidated for what she's gone through. Hello, Cece. Trying to get back to where you are. There you are. Hi. Good to see you. Welcome. Yeah. Bill Nye, the science guy. Yeah, the judge kind of did resemble him a bit. I grew up with that show. Yeah. So that was fun. A few new judges. That was from today. That was the Sunday arraignments docket. I have another one from today as well, but it's about an hour long too, and I'm not going to be able to stay awake for another hour. I'm letting you know right now. If I were to put it on, I would be asleep probably 20 minutes in. That's being generous. So I'm going to call it now, and I know where the good stuff's at. Yep. Well, I'm gonna have to. I'm gonna be going on a just a bender of editing and get as much done as I can today and tomorrow, because Wednesday is my surgery again. And come Wednesday, I'm not gonna feel like being on my computer for anything. Tomorrow I'm supposed to have an appointment. I'm honestly kind of hoping that it's a duplicate appointment. It was booked when he was like, yeah, come in for the next 3 Mondays in a row for wound care and for me to monitor this and blah blah blah. And then he decided, one appointment into that, he's like, no, we have to do surgery again. This isn't going well. And I'm kind of hoping, and then he set up, the pre-op and post-op appointments and everything. And so that this one is left over from the previous ones. And I'm kind of hoping, I'm going to call him in the morning and I'm going to be like, hey, surgery's Wednesday. Nothing's changed since I saw you last Monday. Do you really need me to come in today and then have surgery Wednesday? Or can you just see me Wednesday at 6:30 in the morning? That's going to be fun. So we'll see. We'll see how that goes. I'm hoping I can get out of it. That's what I'm saying. Long story short, I'm hoping I can get out of it. I don't want to go. I hate the car ride. It's an hour-long ride. Just for a 10-minute long appointment. It sucks. It sucks. Yeah, I have tons. Oh, I have tons of Webster. I download her every day. She's all of the Kansas cases. I get all of them if I have the ability. I even have the notifications on my phone for all the Kansas dockets. So when Kansas goes on, I am like boom right there if I can be. Unfortunately, I don't get the ability to all the time. It is a day surgery. They rarely admit you here anymore. Like, I am serious on that. Like, you've got to be near death or having, a limb replaced with titanium or something for them to admit you around here. Even then, I think they'd send you home. Brian Boggs, honey, I missed you, and now I'm gonna go to sleep. Come on, come make the drive. Come snuggle. I'm tired. I'm gonna go to bed. Which one, Regier? Regier just might be a bot. He might be AI. I'm thinking, we met Regier about a year before AI became a thing, right? Right? I'm thinking he was a prototype. Maybe a hologram. He kind of freezes every once in a while. Maybe that's him glitching out. Thank you so much, sweetie. It'll be okay. The doctor didn't listen to me. That's the long and short of it. He didn't listen to me. I told him that my body doesn't do well with sutures specifically is what the one thing that I mentioned. But I told him, like, anything, like, my body rejects any foreign material. He decided it necessary to use a mesh in there, and I didn't know this. I did not know this until we realized, because I've been taking pictures and I've been putting them in this Google Drive folder. Like, everybody has the access to it if they want to see the progress of my foot. It's on I had posted the link on Discord, but I was looking at the pictures and I'm realizing, like, the whole time that it's healing, like, there's a suture that always ever presently stayed, like, at the top, like my body was pushing it out. And so I was like, I wonder if my body's rejecting that. And so I asked him, I had an appointment that day, and I asked him, I said, could this be some type of, like, foreign body rejection to the sutures you did use? Because, like, he used the dissolvable ones, which I've never known myself to have a reaction to those, just the top layer. And you almost saw his face change when I said that. And he was like, I think, well, we need to go back in and remove that mesh. I'm like, what mesh? What? Why did you put something in there? You know, so it'll be an easy one, apparently, hopefully. I don't know that one. I'll have to look that one up. So, anyways, the girls are telling me I'm tired. Actually, I think this time it's just Emily telling me I'm tired. So, I'm going to go to bed. I love you all. And I really appreciate you guys coming out and hanging out with me. It was fun, and I promise you tomorrow is going to be fun again. Salty Buddha, just in time for your cleaning lady to arrive. Nope, you didn't this time. This was Emily. This was Emily. And now Peter. Oh my gosh, you guys. Y'all are terrible. But I love every one of you. Every stinking one of you. Thank you for being here. Yes, with the implication of go to bed. All right. Be safe, be well, sleep sweet, and much love.